Good morning or good afternoon. The court will take up the next case, cause number C190090CPS. This is in the interest of Senada Oviedo and one Pablo Oviedo children. The case is set for a bench trial today. The hearing is being conducted pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the trial today on behalf of the department is caseworker Brendan Ziders and regional attorney Deborah Keenum. The mother, Laura Hernandez, who's been personally served with citation notice of suit in this case, is not present. Nathan Butler has been appointed as her attorney ad litem, and Mr. Butler is present. The father of the child is one Pablo Oviedo, who I understand resides in the country of Mexico. He has not been personally served at this point, according to the court file, and he is not present. The court has appointed Marciela Mendoza as his attorney ad litem, and Ms. Mendoza is participating in the hearing today. The attorney ad litem for the children is Brad Harrelson, and Mr. Harrelson is participating in the hearing today. Connie Gowain and Carol Pierce are the CASA guardian ad litem representatives for the children, and they are participating in the hearing today, and the children are excused from participating in today's hearing. All right, as I know, we're set for a bench trial today. Ms. Keenum, where do we stand from the department's perspective on being ready to proceed?
Your Honor, we have filed our report with the court on our efforts to complete service on the father. We have still not been able to complete service on the father. We would ask that the court either find that the department has exercised due diligence in attempting to serve Mr. Oviedo, or we ask for a continuance at this time.
Thank you. Mr. Butler? Do you have, are you ready to proceed, and do you have a position, if the court were to find the department had exercised due diligence and was otherwise ready to proceed, do you have a position on being ready to proceed, and alternatively on their motion for continuance?
Your Honor, I am requesting a motion for continuance myself. The whereabouts of my client, I believe, are unknown. I don't believe she's had any contact with the department nor with me pretty much since the case has begun. As I recall, I think the last contact with her was in 2018 when she, I believe, showed up to a birthday party for one of the children. I don't know where she is or how to get in contact with her, and she is obviously not here. My other concern, Your Honor, is even though the departments may have exercised due diligence on this, I think I think at least we know where he is, and there should be some alternative manner of service. I mean, if he's sitting in a prison and the prison won't let us serve him, I think the court should probably enter an order stating we can go post it on the front of the prison door there in Mexico and get somebody down there to go do it. I don't know what else could be done, but I think there at least needs to be, at least by publication or something, some service on him. So I'm urging a continuance on this matter. And in addition, Your Honor, now this is the case where apparently there was a letter received by CASA either yesterday or today that from their filing purports to be from him, but it's in Spanish, so I don't know what it says. Ms. Mendoza may be able to address that.
All right, thank you. Ms. Mendoza, do you have a position on being ready to proceed with the trial and also the request for continuance?
Yes, Your Honor. I am not prepared to move forward with the trial as my client has not been served in this case. I would be in agreement with a continuance. I believe there should be some way to get him served. Until then, I can't really do anything for him in this case. As far as the letter that Mr. Butler mentioned, I was not aware of it, but I would be willing to look at it and see if that could help us in any way to move forward.
Thank you. Mr. Harrelson, you have any position on the request for continuance?
Your Honor, I don't have a position on the request. On the continuance, if the court does proceed to trial, I'm as ready as I'll ever be to go forward, but I understand the concerns of the other parties.
All right, thank you. Ms. Gawain and Ms. Pierce, anything you want to address about any continuance?
Judge, I've translated the letter in case somebody wants to read it.
Your Honor, would CASA provide a copy of this letter to the parties? We've not seen this letter.
Well, it was filed with a court, looks like earlier today.
Last night at 5:08, it was filed.
Yeah, it looks like it was filed, yeah, 5:07. But there's a copy of what I gather purports to be a letter from Mr. Oviedo to Ms. Pierce. With the exception of the first page, the court will take additional notice of that letter to the extent it reflects it appears to have been written on May 14, 2021. Purports to be from Juan Pablo Oviedo Rios. It is in Spanish, and based on my rudimentary Spanish understanding, I have a general idea of the gist of it, but I'm not going to express any opinions on what the specifics of it, since I'm not a certified interpreter, and my interpretation of it may be
Your Honor,
inaccurate.
if I may, I'm requesting the court order that a translation of that letter be prepared and English version of it submitted to the party so we can know what it says.
Your Honor, and I would ask that you review e-file. I have checked my e-file and I do not show that I was served on that. I'm not showing it. Anything that came in at 5:08?
It's an attachment to the CASA report that I received.
I'm not showing that I received anything from CASA.
Yes,
Miss
you did.
Deborah, you sent us an email that shows that you did receive it, and today. And
So that 5:08 that I forwarded was not our document. It was your CASA report.
that's
Yes.
right.
Okay. All right.
And I
And
have
so-
it translated. I translated it through Word.
And Ms. Pierce, I appreciate you doing that. Unfortunately, I'm not authorized to, unless you're a certified translator appointed by the court, I'm not authorized to hear what it says, but I appreciate you doing that. And I certainly appreciate you filing it with the court. But if we do continue the case, one of the things I was contemplating is exactly what Mr. Butler suggested, which is ordering that document to be translated. It may have some legal effect in the case. It may not, depending on what's set forth in there, and also exactly how it came to be before the court. Just because he sent you a letter, that doesn't necessarily constitute an answer that would subject him to the court's jurisdiction, but it potentially could. He may also have made statements in there that could address the jurisdiction issue. But I think the best way to proceed with that would be to have it interpreted by have a certified Spanish language interpreter interpret the letter prepare a report to the court and be filed with the court, and the other parties would have it, and then we'd have an official version of what he may have said, which may be entirely consistent with what you have, Ms. Pierce. May not be, I don't know. I believe based on the announcements of the parties, I don't think I have much choice but to, given the fact that Mr. Oviedo, at least as far as the court can tell from the state of the court file at this point, has not been served. He has apparently responded in some fashion to this suit now. I think the court is going to need to have this document interpreted to give the parties some additional time. It may provide some information, Ms. Mendoza, where you may be able to communicate with him, and I'd ask you to do so, follow up. There are some addresses in there. I think there's also maybe even some phone numbers in there. And I'd ask you to follow up on any of that because in part you were appointed effectively as for a missing parent to help the department and the court with diligence in trying to locate and communicate with them about that. So I'd ask you to follow up with them on any leads that it may provide so that you can communicate with him. And since I understand you speak Spanish, you may be able to speak with him and get a better
Yes, Your Honor.
understanding of what his position is.
I will.
In that case. So I'd appreciate any efforts you can make.
I will.
in
May I
regard
ask
to this.
a question of CASA?
Yes, ma'am.
Okay. How, when did y'all make contact with him? How long did it take to receive an answer?
He wrote this on May 14th in response to my, I believe, March parent letter. We received it yesterday at the office. It was
Okay.
postmarked June 2nd and arrived at CASA's office on the 3rd yesterday.
Okay, so you sent him correspondence in March. It looks like he wrote that in May, and then it arrived to your office yesterday.
Yesterday, yes.
Okay,
He said he received it in May. May 14th is when he received it.
And I would note, just again, based on my rudimentary understanding of the Spanish language, that at the end of the letter, I think the gist of it is, I think he may still be incarcerated, but he, if I'm not mistaken, is identifying some relatives or family of his. I don't know if he's identifying them as potential placements or ways to contact him, but it does list what appear to be some phone numbers in the area where he lives of some other people in Alejandra Rios
That's his father.
and Alejandro Herrera are both listed on there with phone numbers. So that may provide some additional resources for the parties to try to communicate further with him regarding the case. So I'd ask everyone involved to follow up on that. The court is going to find, pursuant to emergency orders of the Texas Supreme Court, that this case, extraordinary circumstances exist that necessitate the department remaining as temporary managing conservator of the children and continuing the department as temporary managing conservator of the children is in the best interest of the children. Under the existing Supreme Court order, as I understand it, the maximum time period I can extend this out to at this time is December 1st, 2021. And so I'm going to make the findings required to extend that dismissal date out based on, or make those orders based on those findings that extraordinary circumstances exist, and it's in the best interest to extend the dismissal date. I am pursuant to Texas Rule of Evidence 1009. I am going to appoint and order a certified Spanish language translator to translate the letter that was received from Mr. Oviedo and file it with the court and provide it to the other parties in the case as quickly as that can occur. Under that rule, it does provide if anyone has any conflicting interpretation of that letter after it's been interpreted by the court's interpreter, you have a time period to file that. I'm going to shorten that time period to be by the next permanency hearing. I'm trusting that I can get an interpreter to have this interpreted and filed prior to the next permanency hearing. So if anyone is not satisfied with the interpretation that's provided by the court's interpreter, you'll have an alternative option to file your own interpretation of that document, but you'll need to file it by the time of the next permanency hearing, which will be set out of ways to allow time to get this interpretation done. Ms. Keenum, I'm going to direct the department to research and file with the court a trial brief on any alternative methods that might be available to serve Mr. Oviedo other than through the mechanisms that have been used now. My understanding of the law is basically under the Hague Convention, Mexico has indicated that you have to go through their agency to have service completed. I will note, however, that in another case, Mr. Jett, I think, was representing the department. We had a similar situation, and the department filed a motion in that case requesting the court make certain findings in the Hague Convention that the department had satisfied its requirements of due diligence to try to get him served pursuant to the Hague Convention and pursuant to Mexico's requirements. And I suggest the department may want to look carefully at whether a similar motion might be feasible to file with a supporting affidavit that would, because in that case, as I recall, the court found that the department had satisfied its requirements when we proceeded with a trial in that case based on that. So I'd ask y'all to look at that and see if that's something that might work
Yes,
as
sir.
an alternative to service. In the meantime, I'd ask the department to continue its effort to locate Mr. Hernandez. If you get any additional information, to let Mr. Butler know so he can represent her interests. Well, thank you again on this difficult and frankly frustrating case. I believe everybody's trying their best to get this to a resolution. I'm hopeful that we can find some mechanism by which we can do this. And while it's not much, frankly, buoyed that after 3 or 4 years, we finally have actually received something from Mr. Oviedo. So,
May I ask something?
absolutely, Mr. Harrelson.
Thank you, Judge. Is the department still going to attempt service, or are we just stopping that right now and moving?
So we'll request another check and send it back out. If you'll note on the timeline, I think what's frustrating is we got that service to that entity in December of 2019, and the service wasn't effective. We didn't receive notice that anything had happened until March of 2021, that we knew that it had been, that something had occurred and they'd received a document back at the central registry in Mexico. And then we didn't receive actual paperwork. It took months for them to ship out the paperwork because we received information that they'll ship it out based on priority. And so we didn't receive it back, a copy, until May, June of 2021. So that's the frustration of the time frame. And in the meantime, we've actually gone and met with him. We've sent individuals to meet with him in person at that facility because he previously had signed a waiver and he's not interested in signing that waiver anymore.
Well, and what it looks like from your report is what's being presented to him is another waiver. Do you have a citation that can be served on him with a return file? Because he can.
We cannot that person can't give them a citation. The citation has to go through the central agency that has to serve him. And that's what takes that amount of time.
Okay, so, but there is a citation in the works that regardless of whether he signs a waiver of service, which he could refuse to again, there is a possibility that he could be served with citation and therefore be deemed served if he defaults.
Yes, and I would encourage the department, even though I know it's difficult, through the agency they contract with and with the central agency in Mexico, since you have an address, I think you will find, as I recall, the language from the Hague Convention from another case, to try to establish you've done everything you can do. I think y'all need to make sure you have something in writing where you have forwarded that information onto them and made a request for them to do it. In that case, basically, the department had done everything they could pursuant to the Hague Convention and the requirements of the Mexican adoption of the Hague Convention, the treaty. Mexico basically, as I understand it, adopted a provision that said the Hague Convention gives you various ways to try to serve somebody, but if the receiving state, in this case Mexico, says, no, this is the only way you can serve one of our citizens, then that's the only way you can serve them. And they're supposed to designate a specific agency, which I think is DNS in Mexico, to receive service and execute it. But there is something of an out clause in the Hague Convention, as I understand it, that basically says, well, if you, the transmitting state, have sent everything you can to them in a reasonable amount of time, I want to say 6 months, but I'm not sure it actually says 6 months, has passed and they have not accomplished that, then you've satisfied the requirements and you can proceed with your case. And so you're not totally dependent on some state that just doesn't want to get somebody served, serving them. And so there is a provision, but it does require, from the department standpoint, you to have done pretty much everything you can to get them served based on the information you have. So I would ask y'all to look at that very carefully. Mr. Jett drafted a motion in that other case with an attached affidavit, kind of laying out everything they've done to show all the steps that they try to do. And that basically the way I interpreted that was the department's done everything they can do. They can't do anything else to get this guy served. If Mexico won't serve him, that's not going to stop the case from proceeding at that point. But that's what y'all need to try to do, to look at that and see. In the interim, I'd ask Ms. Mendoza if she can follow up. It may work out quicker if she's actually able to get a hold of the gentleman. That may not be feasible given his circumstances or his willingness to cooperate, but we may be able to determine one way or the other which way his position is, and at least get him involved in the case where he can participate, even if it may be by phone or some other manner, so that we have some jurisdiction to proceed forward and we're not holding these children's lives up any further than we already have.
Judge,
Yes, ma'am.
I don't know what the procedures would be to visit him where he is incarcerated, but would the court approve that I travel there? If that's, I mean, that would probably be faster than, it seems like correspondence takes a while. So I don't know what the court's position would be on that.
Well, one, thank you for being willing to do that. Second, normally my immediate response would be, because of the cost, would be no. However, given our circumstances in this case, I'm not ruling that out at all. So I think if you get in communication with him where you think that may, or do enough determination that you think that may be a productive exercise to get some resolution on how to proceed. I'm not saying a resolution in the case, but at least getting the jurisdictional issue resolved so we can either authorize you to represent him in the case. In case he wants to participate by phone, we try to make something out. if we can get something worked out where he can participate in the case, we're just stuck right now without that. So that's a long way of saying, if you feel like that would happen, the only thing I would ask you do, Ms. Mendoza, would be if you get to the point where you feel that's necessary, you kind of give me a budget.
Okay,
I've had other attorneys where they've had to travel, do that, and they'll basically say, well, if I'm going to fly to this area, get a rental car, stay at a hotel, it looks like this, I'm going to have my time. And so I have some kind of budget so that I can base a decision on as to whether the economics would make sense with the necessity and the legality. Obviously, the other thing I'd want to make sure of is, and most importantly, given the way COVID is kicked up right now, that you're safe, you're not exposing yourself in that situation. So that'd be another factor I'd certainly want you to consider as well. But I
okay,
appreciate your willingness to consider that, and I'm certainly willing to consider it as well.
okay. Well, I'll look into it and see what, if I can communicate through Mel, and hopefully if that's fast enough, then that's a good way to do it. But if not, I mean, then I'll look into what it would take to go there and meet with him in person, if that's even possible at all as well, because of where he's incarcerated.
Well, and you can get in, I don't know what the circumstances would be on that, because you might be able to get there and then the facility says, well, because of COVID, we're not letting anybody in
Right.
or out.
Right,
And that may be a showstopper right there, and you'd want to know that before you got there.
right. So, right. So I need to know all of that first before even.
Right. But
Attempting.
all that being said, if that's the way we need to go and you're willing to do that, I'm certainly willing to entertain that as one trip. I'm not sure that's a particularly scenic spot, but it'd be at least a trip for you.
Right. So I can't buy plane tickets to Cancun and go that route.
I didn't say how you had to route it. I just said you had to give me that. You had to give
Your
me
Honor,
a-
if she's going to Cancun, I insist on going so I can interview him myself to see if he knows where my client is.
Well, you're going to have to get some information that Mr. Hernandez is down there first, I think. All right. All right. Well, thank you. Again, I appreciate everybody's willingness to try to help us resolve this, but those will be the orders of court. We'll extend the dismissal date. I'll get some new trial dates out and hearing dates. I'm going to have an interpreter interpret that letter, and once they interpret it, it'll get out to everybody. And then if y'all have any questions about that, you will have the right under that rule to file an alternative one if you should wish to do so. And I asked the department to follow up on the Hague Convention issue and see if a motion along the lines we had in the other case might fit, depending. It may not, since we know where he's at this point, but it may be one other way to try to address this as well. The dismissal date will be December 1st at this point. All right, thank you.
Thank you, Your
We'll be in
Honor.
recess.